Minister with responsibility for land titling, Minister Montague, you've probably heard him say there are two books your name should be in, the Book of Life and the Book of Titles. Today, we're focusing on one that we can actually help you with. Welcome to The Explainer. I'm Rasheedah Menzie, your host, and in this episode, we are breaking down what land title is, why it matters, and how the process actually works. But before we get into it, remember to like, share, and subscribe to our YouTube channel. Our first question, what is a land title, and why is it important to have one? Now, a land title refers to the document issued by the National Land Agency's Land Title Division that provides information about ownership, encumbrances, and location for specified properties. So, what happens if you live on land that you don't have a title to? Well, if you occupy land and have no registered land title to prove your ownership, it becomes a little difficult to access the full potential of that property. Mortgage institutions may be a little bit reluctant to do business with you, and you may find it a little difficult to sell that particular property. It may also be difficult to disprove challenges to your ownership. So do it the legal way. Question number 3. How does the land titling process actually work? Many people ask this because they're saying, you have to stamp this, sign this, bring this here, bring that there, but I'm going to lay it down for you. Simple. Now, if the land is not already registered, a person can apply for a title under the Registration of Titles Act. Once the application is submitted, it is reviewed by a referee of titles who examines the claim and supporting documents to determine whether the applicant has a valid right to the property or if they don't. Now, if the claim is approved, the applicant is required to publish a notice in a daily newspaper. This gives anyone who may have an interest in the land an opportunity to raise an objection within the set time periods that are given to them. If no objections are received during that notice period and all legal requirements have been satisfied, a registered land title is then issued to the applicant's name. A land title may also be issued from unregistered land pursuant to Section 28A of the Registration Titles Act under the government's systematic adjudication land titling process. So see, it's a very simple process, and you have guiding persons to help you as you go through this process. Next question. What documents are required to apply for a land title? Well, when applying for a land title through the National Land Agency, several key documents must be submitted. You have no option of this, it has to be submitted. These include a completed application form, a statutory declaration from the applicant, and supporting declarations from persons who can confirm your claim to the property. You'll also need proof that property taxes are paid, a pre-checked survey diagram of the land, and any other documents that support your ownership, such as a deed of agreement or for sale. In some cases though, particularly under special provisions, an adjudication certificate, it is issued by the Director of Adjudication Services, and that may also be required. Now, how long does the land titling process usually take? The processing time is specific to each application and the unique circumstances of each application. The referee of titles may have multiple requisitions before he is satisfied that the application should be approved. The referee of titles also has the sole discretionary power to set the statutory notice period within which objections to the application may be made. Next question. Can land be titled if it has been occupied informally for years? Yes. An application can be made to bring land under the Registration of Titles Act and have a certificate of title issued once an applicant can show 1. They have the best right of ownership. 2, they have been in possession and can appropriately trace the roots of their possession of the title. And 3, have met all other procedural and legal requirements. Moving to our next question. What is a caveat and why is it important? Now, a caveat is a legal notice lodged with the National Land Agency that signals someone has an interest in a piece of registered land and wants that interest protected. For example, a purchaser or a beneficiary or a creditor can lodge a caveat with the Land Titles Division of the NLA to prevent the property from being sold, transferred, or mortgaged without their knowledge. Once a caveat is in place, no transaction at all can be registered on the property unless the person who lodged the caveat gives consent, withdraws it, or has a court order remove it. Also, in some cases, a caveat can also lapse if required legal steps are not taken within the prescribed time period. In simple terms, a caveat acts as a legal safeguard for persons. It protects a person's interest in land and ensures that the property cannot be dealt with until the matter is properly resolved. Now, on to our next question that is of keen interest to a lot of Jamaicans, I'm sure. Dead left land. Now, the question is, who has the legal right to sell land belonging to a deceased person in Jamaica? Now, the legal right to sell land belonging to a deceased person lies exclusively with the personal representative of the deceased estate. So this person must be officially appointed through one of the following: a grant of probate, and this is if the deceased left a will or named an executor, or a grant of letters of administration, and this is if the deceased, died without a will in place. Until such a grant is obtained, no individual has authority to dispose of real property forming part of the deceased's estate. Where the deceased left minor beneficiaries or the estate falls within statutory thresholds, such as maybe $10 million, the Administrator General's Department acts as the estate's administrator pursuant. On to our next question. What are common misconceptions about land titling? A common misconception is that possession or long occupation of land automatically confers legal ownership. Wrong. False. Legal ownership in Jamaica depends on valid documentary title and a proper registration. Another misconception is that a will alone transfers ownership to land, whereas a grant of probate or letters of administration and transmission of titles are required. Some persons also believe that land tax receipts and utility bills prove ownership, but these documents only show occupation and not legal titles. And for a final question for this segment, how does land titling contribute to long-term wealth and security? And I know you guys want to hear the answer to this. Land titling provides legal certainty of ownership, making land a secure asset that can be sold, leased, or mortgaged. A registered title enables owners to access financing, investment in property developments, and pass land to future generations with reduced risk of disputes. Registered land enhances economic stability, intergenerational wealth, and protects against fraud and unlawful claims. And that's a wrap on land titling. Securing a land title, as you see, isn't just paperwork. It's protection, it's security, and it's an important step towards long-term stability for you and your family. This has been The Explainer. If you found this helpful, be sure to subscribe to our YouTube channel and follow us on our social media platforms at MEGID_JM. That is MEGID_JM. I'm Rasheedah. See you next time.